Good morning.
Good morning.
Hello, good morning.
Morning, all. Hello.
Good morning.
Morning. I have a question. This is Kendra. I missed class last week. I did some reading and I went through the information. And you know how we do at the end of the class when she asks the pages? Can someone assist me? I just want to make sure that I am on the right track with the pages.
I think we're on page 70.
No, I understand that. I was saying, thank you for responding, actually. I was saying I went through the employee-employer contract because I missed last class. And you know, at the end, when we go on the page and she says, what page can you find the contract? Like the questions at the end.
Oh, you mean that? Morning,
Yeah,
by the way.
I just want to make sure that I got the pages, like I went through it after reading, and I just wanted to ensure that the pages that I have are actually the pages that were correct from last class.
It's a good thing you asked because I only get up to like number 8 with the pages.
Okay, so what I was asking was like, okay, like for number 1, it says, what is a contract? And she would say, what page can you find it on? And I was wondering, like, you guys went through that, and I just wanted to know what pages you guys got because I wrote my own pages since I missed the class. I just wanted to make sure that, right.
I could give you what I have.
Okay, so number 1 page was, what was the page, 39?
Number 1 and 2 is 39.
Number 3 was
40.
Yeah, I got that. And number 4.
4 and 5 is 41.
Number 4 is 41?
Yeah.
Oh, I had 40. Okay, thank you. See, that's why I wanted to confirm. Okay.
Yeah, 4 and 5 is 41. 6 and 7 is 46.
Okay.
8
I was off
is
at
40.
7.
8 is 49.
Number 8?
Yeah.
49?
Yeah. That's as far. That's as far as I have.
Oh. And number 9. Okay. Well, thank you, Duran.
No problem.
9, 10, 11, and 12. Okay.
Hi, Kendra.
Good morning.
Morning. I got page 43 for number 9.
Okay, I had that too. Yes.
Okay, I didn't get number 10.
I used 40. I had 43 for 10 too. I don't know. That's why I wanted to clarify. On 11?
Page 51. Okay,
and 52.
Thank you. Page number 12 is page 53.
Okay, thank you, Nikita. Though I got those ones too.
No
I
problem.
got 51 and 52 for 11 and 53 for 12. Thank you,
but
Nikita.
I think you're just off by 1 page, but it may be a case where the information starts on 1 page and continues on another.
Yeah, so, for page 11, yes.
Yeah, it may not be off. Yeah.
Okay.
Okay.
Thank you, Nikita and Duran. Thank you, guys.
No problem. Hi, sorry, Kendra.
Hey.
Hi, for number 10, I'm just looking at the question and in the book, and I imagine that page 43 should be for number 10, which are the remedies for breach of contract.
Yeah, that's what I had.
I had damages, action for agreed sum and quantum merit.
Oh, yeah, so I got 43, yes.
Okay. All right.
Duran, you got the rest you missed?
Yeah, thank you so much.
Okay.
I needed that.
Good morning.
Good morning.
Morning.
Good morning.
Trust everyone's well this morning.
Yes, ma'am.
Good. Okay. Before we get started, let's just do our register for the office. You can just give me your names, please.
Good morning, Shanice McDonald.
Okay, thank you.
Kendra Martin.
Mm-hmm.
Tadashi Palacios.
T. Palacios,
And Nikita Isaacs.
And Isaacs, okay.
Catherine Zervos.
C. Servos.
Siobhan Linden.
Okay.
Bridget Roll.
BRO. Okay.
Ron Fortune.
Unfortunate. Thank you.
Sherilyn Hunt.
And thank you. Three. I have 9. Okay. 2, 4, 6, 8, 10, 11. Okay, I'm missing 2 more. Okay, Smith. Okay, Smith, your mic isn't working yet. Okay, I have Smith. Anyone else? I may not can. Okay. Thanks. Okay. Okay, last week we reviewed a big chapter. You were able to look at it anymore? Module 3? I didn't lose you, eh?
And no, we have you. It was a difficult chapter to go through.
Okay. You understand it, or you still need some more time?
I have a better understanding of it, having gone through it the second time and then doing the questions at the end. It's just a lot of information to absorb.
Right. Did you get the labor law book from the office?
You mean my copy of the manual for the course?
No, labor law in the Bahamas by Emmanuel Osadabe, Justice Osadabe.
Oh, no.
She was supposed to send you all a note to pick it up.
Oh.
No?
No.
No.
See anything?
Okay.
My challenge would be Amini Luthrop.
Okay.
Oh.
Okay, so you'll have to see how you could arrange that. I know she had called me earlier to say she was sending out a note. I thought she did already.
No.
Okay, so the book is at the office for you to collect. It would be helpful because it breaks down the manual as well, and it breaks out the cases. So it's really a good book, an easy read as well.
What's it called again?
Labor Law in the Bahamas by Emmanuel Osadabe.
The labor board wasn't very helpful either.
No way.
It seems when you call the ministries, like example, when you told us to check out the class for the industrial tribunal, it seems like a lot of these offices don't really know the information for the jobs that they're working, because you call them and they're like, go to the website, but half of the information is not even there.
Yeah, I don't know. You know, they transfer them in and out so often, and then it just shows you what you're dealing with when you get in these places.
My point, exactly.
Yeah, so you have to, that's why you have to know for yourself, hey, because you think they're the experts, but they are truly not. So you could teach them a thing or two when you get there and know your forms you need to have and all that stuff.
Hopefully.
And the time. Yes. So that's why it's good to know, hey, because you know sometimes people just rely on the say-so of others, but when you know for yourself, there's not much you can, like, that's why a lot of people in the United States are so well informed about their rights, and Bahamians still to this day don't know a lot of their rights, and they're not able to enforce them as a result.
Because like me, I thought I can call the agency and get all the information, but you call there and they transfer you to somebody and the person is like, well, you know, I'm not really familiar, and the person who can do that isn't here. And did you check the website? Everything is not on the website.
And the website isn't so user-friendly, and it doesn't provide you with the information you're looking for, because it gives you an outline, but it's still left for you to comprehend what they're trying to say.
Because
and,
when
and they don't seem to manage the websites. The websites
I was just going to say that.
Information.
Right.
You don't have anyone that manages the website. Everything is what's been.
Because the act does not speak specifically to the part-time employee. And when you try to ask these questions, they don't even know themselves.
No, because they trying to figure it out themselves.
Wow.
And it's only when they get before the tribunal, then the tribunal is looking for, I guess, direction from the consul or the persons who are there to see how you come about being a part-time, what benefits you're entitled to. So you would be more or less informing the tribunal at the time, if that's not before them from a previous occasion.
Wow. So you can imagine why workers in this country is so frustrated, because you can be fired and have no recourse because you don't know your rights. The labor department can't help you. And if you can't help yourself, God help us all.
That's just it. But you know what is helpful too? You can look not just to one thing, because you see, it plays into national insurance, employment. You can get some answers from there, because according to how they do and what employment law says, you put the pieces together and you make a whole. But of course, most people are not going to be doing all that work.
But so based on the pieces that I put together, it appears that the part-time worker is entitled basically to the same thing that a full-time worker is entitled to.
Once they reach what?
An agreement. Because they can't be treated any much less or given less concern than a regular worker.
Okay, what benefits they would derive? Their benefits different?
I think it's based on the contract that they signed, because part-time workers basically don't work the same hours, that they don't do the same things basically that a regular worker does. So even though they should be treated fairly, I based on my understanding, I don't think they get the same benefits that a full-time employee does. So to me, it's like they're also like contract workers.
Right. So, and with the contract workers, you get what you're gonna get at the end of the day.
What you agree to in your contract.
Right. So you may not have any benefits. There's no continuity, all of that stuff.
Right.
What about national insurance? Does it matter?
I think you have to still pay national insurance because they are an employee of yours.
Right. So so then you still have to deduct from that part-time person's pay, eh?
Correct. Yes.
Yes.
So I mean, the part-time worker is totally disadvantaged, eh?
Yes, because they're working less hours, and still you have to take out national insurance, and they won't get the same benefits of a full-time employee.
So they won't even get the benefits, and then they are still mandated to pay the same thing as a
regular worker.
Okay. The Institute's office is downtown next to Graham Thompson and Co. Miservos. Okay. It's right on Elizabeth Avenue at the light of Shirley Street and Elizabeth Avenue. It's a pink building, and it shares the building with Graham Thompson. It's the whole Graham Thompson building that's one block to the other.
Okay.
Okay.
All right. Thank you so much.
No problem. We were able to find any bills, anything going on in the house that could help us. We could finish our 5 weeks and nothing.
I'm moving slow.
So
they're busy arguing about other things.
Oh Lord, they look at to spend somebody. That's what it is.
in Grand Bahama, that's the topic right now.
Ms. Dawson.
I
was able to get information. They have the last sitting. They had the first read of 4 bills. 3 of them are reference to pensions.
Okay.
Jayford Edison, Delaveau pension bill, Mary Mitchell pension bill, and Raymond Mackey pension bill. And then there's one, the Bahamas Agriculture and Marine Science Institute Bill, 2022. They're all at the first read.
Okay, then.
They're saying that everything else that was on the floor have already been passed. So,
okay.
And the House will meet again on the 16th.
So we had the first read. What's going to happen next after that?
They got to be presented.
There's a discussion on
of the green paper.
We had the first read already. So it's introduced already in the House. Yeah.
So now they got to
read and then
the second read and the provisions for the bill to be debated.
Okay, so it's going to the second thing. So that's for individual person's pension, because Mary Mitchell was the assistant treasurer at 1.8, or she got appointed to the substantive post, I'm not sure. So they're dealing with individual pensions. I didn't even know they have a whole session just to deal with pensions by itself. Wow.
I know Mr. Delaveau was from Fisheries or Agriculture.
Mm-hmm.
Mr. Markey was from the police, but I'm not sure where Mary Mitchell was from.
Yeah, she was the acting treasurer or something the other day. Okay, so we know what is a contract, eh? What is a contract?
An agreement.
And what are the essential elements we should have in the contract?
The essential elements would be the offer, the acceptance, consideration, intention to create legal relations to capacity and the certainty of terms.
Okay. And what is the contract itself?
An agreement between two or more persons or entities.
Okay. So we have to have offer and acceptance, consideration. What form of acceptance we can show or we'll have?
Verbal, no.
Maybe verbal or physical.
Okay, when it's
acceptance.
and what happens with verbal? What we should do when we do it verbally, especially in an employment contract.
Act on it.
It can either be by your actions or by acknowledging verbally that you accept the offer.
So now, when we have a verbal contract of acceptance, especially in employment, what should happen shortly thereafter?
It should be followed up.
You should have it formally documented.
Yeah, certainly. So it should be reduced to writing, eh?
Yes.
We have a timeline.
Yes.
As soon as possible.
But we had a little timeline in there, eh?
Yeah, I think they did, yes.
It spoke to a timeline.
Y'all remember the timeline?
I remember it spoke to a timeline, yes.
Right, with acceptance, offer acceptance.
The postal rule?
No, they should have reduced it to writing.
I think they did have a time limit. I think they did.
Right, where it was done verbally.
They said it should be included in writing short. I saw it somewhere, hold on.
Mm-hmm.
I did see it.
Period of time, lapses.
Look on page 44 at paragraph 3 at the end.
Oh, within 2 months.
Yes. Of the commencement date of employment.
Of the employment, yeah.
Right.
All right. And what are the 3 main types of contract of employment?
The permanent employee contract, the temporary fixed term employment contract, and the training apprenticeship contract.
Yes.
Okay. And do we have any remedies where there's a breach of contract?
Definitely.
Yeah. What remedies do we have available? We have remedies under what? What laws?
Common law and equitable remedy.
And what is an example of a common law remedy?
Damages.
And equitable?
An injunction.
Okay, good. Okay, so let's move on to module 4. Anyone else came in? I don't have that.
I came in a little late, Laura.
Okay.
Ms. Dawson, sorry.
Okay, 12. Okay. Okay. So that's 2, 4, 6, 8, 10, 12. Okay, I have everyone, looks like. Okay. Now the labor law book would be helpful. I'll give you a little, I'll just give you a note where you can look when you get it. So you'll just put the note on the side of the paragraph. So you'll know to look when you're looking for reading purposes. So after we complete module 4, we should develop knowledge on the distinction between the different types of employees, gain an understanding of the contractual nature of the employer-employee relationship, recognize the duties of an employer and employee, gain knowledge on the rights of the employee in the workplace, and create an awareness of the significance of the employer-employee relationship. Okay, who will help us this morning with reading to get started?
I'll start.
Thank you.
The International Labor Organization, ILO, defines the employer-employee relationship as follows. The employment relationship is the legal link between employers and employees. It exists when a person performs work or services under certain conditions in return for remuneration. It is through the employment relationship, however defined, that reciprocal rights and obligations are created between the employee and the employer. The employer-employee contract is contractual in nature, since the contract of employment may be oral or written, partly oral, partly written, with express and implied terms and governed by the principles of the law of contract. Where there is no formal contract of employment, the Employment Act 2001 imputes a statutory contract of employment with the fundamental terms as outlined in Section 5 of the Act. Similarly, decisions from UK and Bahamian employment law cases also highlight, and in some cases, import certain terms and conditions in contracts of employment that may be silent on or lacking some important terms and conditions. It is important to determine who is an employer and who is an employee under the contract of employment in order to distinguish certain rights, duties, responsibilities, and liabilities under contract. An employer may only owe a legal duty of care and contractual duties to an individual who is recognized as an employee under common law and statute. Similarly, an employee may only owe certain duties and enforce his employment rights against an individual or entity who is legally recognized as an employer.
Okay, so we have the employment relationship, and that is defined in the ILO, International Labor Organization, and it's the legal link between employers and employees, where persons who would have provided work or services under certain condition in return for remuneration. So what we have, what remuneration is?
Payment.
And what we call that in the contract element?
Consideration.
Yes, so we had consideration. So this is a contract, the employer's contract is a contract, and it can be oral, written, partly oral, or partly written with express and implied terms. Now, where we don't provide these employees with a contract of employment, the Employment Act now imputes a statutory contract of employment under Section 5. We went over Section 5, right, of the Employment Act, where we put in what is in there. You all remember that?
No.
The name of the employer and employee.
Right.
Here.
What else we had in there? That was the long chapter last week. I see Mr. Fortune say no.
Section 5. I need to get the Employment Act. I need to print that.
Remember Section 5 last week? That was last week, eh? Oh, that was the week before. These weeks go that quickly. I think that was just last week we read Section 5.
It was last week.
Yeah. You're making me take this was longer. What Section 5? Tell us what the term.
I think I find it.
You're talking about the Employment Act?
Yeah.
Right. Remember, Section 5 was on page 50. What we say?
Yes, right.
I know. You're causing me to worry.
So we want me to read it?
Yeah, just say what imputes. What is imputed if you don't put it in? Go ahead.
Name of the employer or group of employers. Name of the employee. Nature of employment. Where a person is engaged for a fixed period. The rate of wages and other benefits, and where any work is to be performed.
Right, not by piece, but by time, all of that stuff, the number of hours. Yeah. So we have Section 5 will impute where you don't put it in, they don't worry about that. Employment Act steps in, so someone won't be disenfranchised, eh? Okay. So we have, and then they have the employer may only owe a duty of care under certain circumstances where the person is recognized as an employee under common law and statute. And likewise, the employee may only owe certain duties and enforce his employment rights where the person is legally recognized as an employer. Because we have some contracts which may not be legally recognized, right?
Yes.
And what are they? What type of contracts we say they were? Where they're not legally recognized.
Where some people are mentally challenged or drunks or
and what else?
The age to be able to make a contract.
And was not officially a part of the initial contract.
Right, and where Ms. Smith said it's an illegal contract. Remember we said at one point where they're not authorized to do business. We used an example. Remember we talk about when the number houses weren't allowed to do business and persons would not have been recognized as working aid.
Right.
Right. Okay, so let's continue. Any questions before we move? Okay, so let's continue.
Who is an employee? There are generally 3 types of employment status: employee, agency worker, self-employed. An employee is simply an individual who works under a contract of employment, although, as we have outlined earlier in the course manual, there are certain factors that must be considered and determined as to whether an individual is deemed an employee for purpose of employment law. The contract is not required to be in writing, and it is established when the terms and conditions have been agreed with the parties, whether orally or in writing. An employee may be full-time, fixed term, or part-time employee for the purposes of the common law and statute. An agency worker. An agency worker is an individual who works for an employer either under a contract or employment or some other contract by undertaking to provide certain work and or services to the employer. Examples of a worker may be agency workers, short-term contractual individuals, or freelancers. Case law suggests that if an agency worker works for an employer for an extended period of time and other factors demonstrate an employer-employee relationship, then the agency worker may be able to claim certain employment rights and benefits, even when no contract of employment exists. A self-employed person. A self-employed person is a person who works in a business of their own and may be contracted by an employer as an independent contractor to undertake and execute work under the terms and conditions of the contractual agreement between him and the employer, which governs his engagement. It is important to distinguish an employee from these other employment types in order to fully appreciate and recognize the rights, duties, and liabilities that are owed to them by employers and from them in law. The law may analyze the employment status of an individual by taking into account certain key areas. Those are control and independence, mutuality of obligations, interrogation, and I guess others.
Yeah, there's another section, this the page where it was cut off. I have to look for that piece. So y'all have the same book where it was cut off. So let me just get what it is. Employee. Let me get it for you. I don't know if I have it. Let's see. Not there. Okay, we'll get the gist of it in a minute. Okay, who is an employee? There are three types of employment statuses: employee, agency worker, and the self-employed person. Where the employee is, whether it's just an employee, they're under a contract of employment. So we understand fully employer-employee relationship. If the contract isn't in writing, what happens?
It's established within the terms and conditions that have been agreed to.
But if there's nothing for us to follow, what we'll do?
Refer to Section 5 of the Act.
Excellent. Agency work, on the other hand, works under a contract of employment or some other undertaking. So they could be short-term freelancers or short-term contract individuals. Now, where they work for an extended period, then the lines become blurred and they can now try to assume certain other benefits of full-time, because they'll say, I've been continuous, I've been working, there's no break in my contract, you've continuously employed me. They can try to work that in, but they have to look at all the extenuating circumstances before that's considered.
I have a question with that, Ms. Dossett. Right there, what we just spoke about with that. So there's no law that says if an individual works consecutively, I guess for a year, it's not automatic that they become permanent if they were an agency worker?
No, because you're under a contract of employment, and I may renew your contract, but I may change something in it just to cover me to make sure. You see what I'm saying?
Yeah.
So remember we say about these well-drafted contracts. So if I have a contract of employment with you and I want to ensure that you're not able to come after me to say, because the purpose of me doing that contract of employment is so that I don't have to pay you the benefits of a full-time worker, eh? So I only want you working from year to year. When that contract over, I owe you no obligations, you owe me no more. And we can decide whether we're going to renew this contract, eh? So I may say, I have you working now as a teller. I may switch you over to do customer service representative. I may switch you back over to something else. Now, that doesn't stop you from going to the tribunal and them looking at the facts of the case, because they may see through that that's what you were trying to do, and I really was still doing the same job. But of course, I'm just trying to make sure I cover myself. I may, like what we say, what you may do, break you may give them a week or two off just to make sure there's a break in the contract. Instead of it just carrying over without you paying much attention to it. So all of those things may factor in, but you're not automatically permanent after that period of time. Because what we have as an example, who's the primary offender in this?
The employer.
Right, but who we have as an example in the Bahamas who's totally doing this? And
the government.
Yes.
Ms. Dorset, that's what I was alluding. That's what my question was alluding to. And I was going to say not to offend anyone in the class if it is, but that was where my question was alluding to, because you know they have that 52-week program where they would put persons on job sites. And that's why I asked, because if you were one of those persons that were placed on a job and you would have worked consecutively, then is it that organization's duty then to employ you full-time because you would have already put in? That's why I asked if it was a law.
No. So what they do, I know in particular, they usually give them a week or two off after their 52 weeks, just to make sure there's a break. But you have people long before the 52-week program. You have people who have been actually in the service over 30 years and they don't have a contract of employment. They've only been working temp. They don't have confirmation in their post, nothing like that. So we have people who complain about that all the time. And I think the Minister of State and in Labor, I think that's Ms. Glover.
Yeah.
Right. She was saying she was speaking to that to say they want to make sure most of these things were done properly, and persons would now at least be able to be confirmed in their posts or get the promotions. All these things have been happening and overlooked.
Ms. Dorset, I would think that 30 years is more than time for the government to decide whether these persons are going to be permanent. I know that they have to now take into consideration benefits for these persons. Do you think that's why they don't make them permanent?
Right. And then, you'd have to do a lot of things retroactive.
Yes.
Right.
Yes. That's a lot of retroactivity.
But a lot of people been on the people always on TV talking about how long they've been working. Some people who have been janitresses in that system for a long time. It's always the low end workers. They do that. Yeah. So they take advantage of the people just desperate for a job, and they take advantage of them. I think it's really poor. And so what you expect for the private citizen to do, they're going to do the same thing.
I have a niece who's been in immigration. So she was inquiring about the purchase of a home. How can we give her a loan when she doesn't have a confirmed position, even though she's been there 11 years?
Wow. So that's what I'm saying. And those immigration officers, they just were making they just were giving them confirmation in their post the other day. The ones who've been there for almost 4 or 5 years as trainees.
Right.
Yeah. So, and then you had a gentleman who was there almost 40 years who was just getting some promotion.
Holy smoke.
Yeah.
How is it legal to work so long? To work so long as a temporary or contract employee for so long?
And listen, it's not for the people not sending out notes and letters to these people, it just, they set it aside. And from successive governments, the civil servants are really to blame because they are well aware of these situations and they can actually, you know how easy it is to do your job.
Yeah.
They make everything seem like it's difficult. It's not as difficult as it seems, because if the system is working properly, you would get results.
Yes.
Yeah.
But you can imagine working for 40 years that means you have no benefits or even not security of tenure, because they can send you home at any given moment.
Right. And this gentleman who was at immigration, he was supposed to get promotions after promotions, and it's time for him to walk out the door. And he hasn't. The promotion he was supposed to get years and years ago. So I guess he'll go home with the money retroactive to when they make the appointment, because they don't, when they come to you with the appointments, that's the thing about, so they hurt themselves in the end, because you were supposed to get it from 2010 and now it's 2022 and they just giving it to you. So they'll have to pay you 12 years at whatever amount per month you were supposed to get. And then you may have benefits, like you would have changed from 1 week to 2 weeks as vacation. So all those things would be factored in.
Ms. Carson, I have a question. So when you offer a person a contract, I'm sure you won't present someone with a contract saying you're going to be on contract for 40 years. So when these contracts are presented, I guess, to be re-signed, there's no conversation then? Because I'm sure you're not going to say you're going to contract me to work for 40 years.
But sometimes I think they get lost in the system. And they're quite satisfied because they feel like, initially, you just want to get in the door.
Yes.
And then a year goes by, and then you say, Lord, they so do this. And when you look, you're 3 years in, and they've not done anything. You're not even working with a contract now. You just working, and you hope that you get paid the next month, because they may realize and say, well, no, let me just kick you out of the system. So a lot of people stay quiet for a long time. Because they're just trying to get under the radar. And then when they realize this really affecting me, it is now late, and then it's now for them to go back so far just to find what's going on here. So 5 years and you just got fed up. You should have been fed up from the first year, but you just got fed up after 5 years. And it's going to take them another 15 years to sort out what happened at 5 years. And that's how it is in that government system, I think, more than anything.
Ms. Joseph, one of the things we're battling with that, I work in a government office. But what it is, we know those individuals, and every 2 to 3 months we write. Case in point, I have one employee. She's been with us, I think 32 years.
Okay.
And she still doesn't have, but we see light at the end of the tunnel for her. I mean, she's one on the custodian end. So we see light at the end now because we're trying to get her to be able to get a pension. So we have quite a bit of documentation on her. So we try in HR not to lose our people. We because we know how many of them we have. So from time to time, we just write. So even if at the end, we're able to say, listen, we've been trying to get this person sorted out, which almost forces government's hand to give them pension at the end of the road.
And so that's the issue, what I'm saying now. They wait. And so it's not as if it's not in the process, but by the time as they get to recognize or do anything about it, it's so much years later. Now, you may only be able to take that money into retirement, but you weren't able to benefit from it when it was really necessary. Like whilst you had your youth and you wanted to get a house or you wanted to do this, you had to struggle or you paying rent. And so when they give you that lump sum payment, that may not even be sufficient for you to get a house. You're still in the same position you were in as early on. So that's the disadvantage with that system. But you have to, first of all, as much as these people come in, like I say, I think they stay under the radar long enough because they don't want to ruffle the feathers initially. And then it affects them later on when they really trying to get, like what Ms. George said, they would just reach out to HR now when it really becomes dire. If they do it from the beginning. So either you're going to keep me or you're not. But at least let me start kicking up some dust from year 1. So by the time it's year 10, I may get some traction, but they wait until year 5. And then you see how long it takes. You see, that's 32 years, you could imagine. You already finished working now. And some of them may not have been able to do anything with working there. They may have only been able to collect a salary.
So, Ms. Dorset, then I'd ask, is there, I'm not certain if it's ever been done, but is there a legal recourse an employee of the government can take against that?
Well, I don't know, because in some instances, I don't know if they even have contracts. Can you enforce what you don't have?
But I mean,
now,
I understand what you're saying. Because
we can say by conduct, everybody is agreed that I've been working.
Yeah.
But then there's certain, I guess the government is clearly cut as to what should happen when you work in there. You should have a contract of employment, because, you know, the government have a lot of, let's say they're not as limited as a private citizen. So they have a little longer reach in getting things, like they get by with a lot.
Yeah, that's why I asked, because I know where I'm employed. Our contracts, I mean, we have to be on them. We have to be on the ball with those contracts where I am.
Right.
I mean,
so the
when you contract,
the private sector don't have the taxpayers' dollars to just dip in whenever they mess up.
Yeah, that's because they advises 3 months before a contract expiration, we get a notice to reminder 3 months prior that this person contract is coming to an end within the next 3 months, and we got to start working on that if it's going to be extended or if it's going to be terminated. But man, I mean, listening to it about from the government perspective, I say, wow.
Yeah, because it's always on there. But I mean, I think it's just that the system is a little bit clogged, and a lot going on, because it can't be that, because then it goes to that, I think it's the public service after all of these things happen, and then you could get lost up there as well. Your human resources department may do something, but when it goes up there, I don't know what happened. What area you work in, Ms. Stewart? You work in public service, or are you in a different area?
I work with the police.
Okay, so some of your stuff have to go to public service?
They all do. We go to national security and then on to public service.
Okay,
and
so
then
I think that's where the
9-month journey.
Yes, yeah. So you see, it's not just with who you reporting to, it's them having to go outside, and then for these people to now get back to them. So that's where I think everything gets lost in translation right there.
Ms. Dawson, it shouldn't get lost, because when I go to work, I can't have things sitting on my desk and not action. So in all these agencies, people are working.
Right, but you know, I don't know that when you get up there, you get into the red tape. That's the real bureaucracy you going into when you step out of your immediate, I guess, areas.
Wow.
You have to wait on people to get back to you, and these people don't stay at the same desk when you look somebody else in the chair, and then you starting all over.
Honestly, now, Ms. Dorset, if you've been somewhere for a period of time and you don't see where it's benefiting you, wouldn't you leave?
But that's the
bottom of the scale.
It doesn't matter.
Yeah, but they don't. Some people are so glad for a government job.
Oh Lord.
They're not going anywhere. They say, "Oh, I'm working for government," and they're always hoping that I soon get married. They hoping to
and then bear in mind, in government, you don't have to do so much.
Right,
that is true.
The private sector, you can come to work and get lost in the system and do very little and still get paid.
I believe that, because the slackness is what keeps them.
That's all.
The slackness.
But you know, if I was cleaning and working every day, all day, and you try to tell me you won't make it be permanent, I could quit, because I can't, it just don't make no sense. And you know, you on me every day. No, that bathroom ain't clean. The ledge is dusted. They don't have that. When you look, they run and talk shop in the government office.
See, that's what I said. Slackness. That's what it is.
But then I'll ask Ms. Stewart or Ms. Linden, isn't there an end of year review, or isn't there something that's done to measure your output towards, I guess, your growth?
In my organization, but I know my sister works for government too, and it's like, let me share a little bit. They had an outbreak of COVID the other day at the office, right? And it seemed the supervisors aren't really concerned, because they didn't even send them home. They expected them to work in the same environment where the person was who had COVID, even though the person was sent home. So
was this national security building?
Huh?
Was this a national security building?
No, but my thing is, so it seems like, I know at my organization, every year we get an annual appraisal, but it doesn't seem like the same thing happens in a number of these government agencies.
Yeah, we do them annually. We're responsible
With us,
for
we do them
at
the end of every year as well. And that then determines your growth in the organization, and then whether you get an increase, whether you stagnant, whether you need to buckle up. Oh my goodness.
Well, it don't seem like that is important in the government.
Does not necessarily translate to an increase in salary, but
it doesn't seem like the government workers are concerned, like somebody mentioned earlier, because I'm not really getting paid. When my sister told me what her increment was, I almost fell out because I was like, what? And if you at your bar, no one is even concerned to see if they should open the scale, and if you reach that bar, you just don't get anything.
But they won't increase the age though. They didn't hesitate to increase the age from 60 to 65. Wow.
You have to wait a little longer to get your benefit.
On a 40-year contract?
Yeah.
Well, praise the Lord, 10 years, and we can retire at 55. So
you in a good place there. You in a
good thank God for that.
It's small, but serious.
Right, serious. So I see why the government agencies are the way they are.
Certainly. Now we go on to who is an employer.
Who is an employer? An employer is an individual, business, or legal entity that hires another individual or individuals to work under a contract of employment as an employee or employees. The employer has certain duties and responsibilities to his employees under the express and implied terms of the contract of employment. These duties are both contractual and tortuous in nature. The employer is obliged to comply with the terms and conditions of the contract of employment and any additional requirements under law. He also owes a duty of care under the law of tort to ensure that the workplace is safe. Example, the occupier's liability. His employees and/or agents comply with the legal mandate of their duties. Example, vicarious liability. And that he exercises his actual and apparent authority responsibly and professionally. Professional negligence.
Okay, so we have the employer, and they are a business, individual, or legal entity which hires another individual or individuals to work under a contract of employment. And we have them as employee or employees. So he has duties and responsibilities to his employee, under the express and implied terms of the contract. And if he don't have these express or implied terms, we can go to the Employment Act and we will impute these terms, implied or expressed. And they are both contractual and tortious in nature. So he can be liable for, he can be liable in tort or in contract. So he's obliged to comply with the terms, and he owes a duty of care under the law of tort to ensure the workplace is safe. That's occupier's liability. We could, where I work in and something happens to me, I could sue you. Or to comply with the legal mandate of the duties, vicarious. So vicarious means where your employees would have done something in the course of their employment, would we say you would be responsible for them, right? So if your employee is driving your truck and they mash my car, I sue in both you and the employee, yes? And where the person exercises his actual apparent authority responsibly and professionally. So in professional negligence, what we can use for an example for where he's responsible and the employee.
This industrial accidents.
But this professional negligence, what happens there? When we go in the bank, what happens? Do we meet the bank or we meet one of the employees of the bank?
An employee.
Right, so when they give us some information and it's not correct, or they do something that's who's responsible?
The bank.
So that's profession. That's they're acting under their actual or apparent authority when they're dealing with you. The employer gave them actual, or based on them being there, it seems apparent that they have the authority to deal with you. So that's where the professional negligence will come in. So this is where we can now sue the employer for the actions of his employees under the contract or in tort. Okay, the duties. Now these important sections here, we should know the duties of an employer and the duties of the employees. So who's gonna do the duties of the employer to the employee? Any questions so far?
I have a question, Ms. Dawson.
Okay.
Been reading this and it says he also owes a duty of care under the law of tort to ensure that the workplace is safe, occupiers liability. And based on where we are now in this whole environment, this whole COVID environment. And I think someone had spoken about someone being employed in an organization where someone was sick, but they still make you come to work knowing someone in that place was sick. That right. Isn't that's against this
so
whole.
What laws protect us with that?
Emergency powers?
No, we have a law under employment law. When we start out, remember those laws would be what we need to have in hand.
And national insurance and all of them, yes.
Which one we think will come into play?
The Health Act?
Right, the health and safety, right? In the workplace. We have that where we'll pull that out for them, eh? Because as much as people try to pull, they say, okay, well, COVID is a pandemic and all this. Now, if COVID just affects me like any other, but if I get sick to the point where I am on death door or I actually die, you think the estate won't go after the employer?
Yes.
Must.
So they have a duty of care. Under what?
The Health and Safety Act.
Right. And so that's something I can go now, and because you have Health and Safety at Work Act, you could just look in there and see what their duty of care is.
Wow. Yeah.
Remember the law, the primary legislation that deals with employment law will factor in. So you look at all these things and you can become a legal guru on employment law for your organization. So that's page 18 where we'll find all those acts, eh?
Yeah.
Okay. Go ahead. Who's going to help us with duties?
I'll take that.
Thank you.
Duties of an employer to an employee. The duties of an employer to an employee may be outlined in the contract of employment, but may also be expressed or implied by common law and statute, particularly where the contract of employment is silent of some of these duties. An employer has some of the following duties under law. Duty to pay his employee the wages and salary agreed under the terms of the contract of employment. In the absence of a remuneration clause in the contract of employment regarding the payment of wages and salaries, the common law requires employers to pay employees a reasonable sum of money for services rendered, particularly for work. 2, duty to provide the employee with an itemized payment slip statement outlining his wages, salaries, national insurance contributions, and pension contributions, if applicable. See Employment Act 2001. 3, duty to ensure, as far as is reasonably practicable, the health, safety, and welfare of his employees and protect them from risk arising from work under the provisions of the Health and Safety Act. The employer must also do the following in terms of health and safety at work. A, provide information and training on health and safety conditions and standards. B, issue a health and safety policy. C, control the use, storage, and maintenance of dangerous substances and control the emissions of noxious or offensive substances in the air, work environment. D, establish safety committees as and when necessary. E, consult with unions regarding health and safety information, training, and standards. 4, duty to take reasonable care to ensure that the tools, equipment, system, and environment of work in his business are safe and that the employee selected to work in his business are competent to use such tools and equipment safely and perform their work competently. Although the employer is not under an absolute duty under common law to warrant the safety of his employees, Wilson and Clyde Coal Corporation versus English Charlton versus the Forest Printing Ink Company, General Cleaning Contractor Limited versus Christmas, Clifford v. Challen and Son Limited. 5, duty to treat all employees fairly, reasonably, and with respect. Example, with what is fair and reasonable is dependent upon the facts in every case. Robinson versus Crompton Parkinson Limited, Gardner Limited versus Beresford, Donovan versus Invicta Airways Limited. 6, duty to conduct himself, itself, and his business in a manner that does not destroy or damage the relationship of trust and confidence between him and his employees, or in any way affect the employee's future employment prospects. Malik and Anor versus Bank of Credit and Commerce International. 7, duty to indemnify the employee against any claims, debts, or expenses and liabilities reasonably incurred of his employment. 8, duty to provide work where the wages or salaries of the employee are dependent upon work supplied by the employer. Example, employees who work on or are paid commission based upon work performed. Although generally, an employer is not obliged to provide work to an employee if he continues to pay that employee the agreed wages and salaries. 9, duty to pay its and the employee's contributions as required under the National Insurance Act and any legislative amendments, regulations, and subsidiary legislation. 10, duty to provide maternity leave with PAT once in every 3 years to a female employee who is or has been employed for at least 12 months with him in Part 5 Employment Act 2001. 11, where an employer provides an employee with a reference, he is under duty of care not to provide incorrect information, which may damage the employment prospects of the employee seeking to secure employment with another employer. Although generally, an employer has no legal duty to provide an ex-employee with a reference, even upon request. Spring versus Guardian Assurance PLC and Oz.
Okay, so we have the duties of the employer to an employee. So he has a duty to pay the wages. And where we don't have wages, would we say there should be a reasonable sum, and reasonable sum is based on what?
Services rendered.
Right, but if I have not given you an amount, what could be reasonable?
Minimum wage or?
Minimum wage.
Okay, but reasonable is based on the work of a similar nature. So you can't pay me minimum wage to be a truck driver if the truck driver is making $500 a week. So it has to be reasonable within the context of the employment. Okay. Duty to provide the employee with an itemized payment outlining his wages, salary, national insurance contributions, etc. This is important in particular when you get before the labor board, because you see the employer and the employee there. The employer has a duty to do these things. So if you go before the labor board and you say, well, I've been paying them minimum wage, $210 a week. The employee now, you're in a hearsay situation, because the employee, if you don't have any evidence of that, the employee could say, that's not the case. I sometimes make $300, $400 according to what I do. So now, because you don't have any evidence, you now at the mercy of the determination of the labor board to say, because you don't have evidence, we may have to go with what these people say, or we may think what is reasonable based on what is going on here, that is likely on the, what we say, balance of probabilities, what we say? What was the threshold? You see, this what you have to answer right on the dime.
Isn't it on the balance of probability?
What is it? Tell me what we talking about.
The proof that
balance of probability is what? Remember this a quasi-judicial process. What we say? What's the standard of proof?
It's a lesser standard.
Right. It's a balance of probabilities is a lesser standard in terms of proving a case. So what's the civil standard?
Beyond a reasonable doubt.
Right, on the balance of probabilities, but in the quasi-judicial process is on
balance of probabilities
with the lesser standard. So basically, you now put yourself in a position where we have to determine whether on the balance of probabilities, which one of these stories are true, right?
Ms. Dawson,
huh?
Are you saying to me that anyone who's paid in cash, that is against the law?
You could pay me in cash, but you have to make a note of what you paying me, how you paying me, what is the, what you paying me? You paying me cash for what? The week of January 1st to January 7th. What is taken out of that? Is national insurance has already been deducted. Yep. See, you're doing that as a receipt for your own purposes, because these people could come back and say she's already taken the national insurance contribution of the money.
Why I'm asking is because my son works in a family business and he's paid in cash. I have never, and when I say a pay slip, I've never seen any written itemized list of what is being deducted from his salary.
So they are in problems, eh? Because when if he has any dispute with them and he goes to prove his case, it's now on the balance of probabilities that what he says is what really happened, because the employer knows better. He's supposed to provide him with a slip.
And why I'm asking is because, you know, as I learn, I put these things into practice, and I would not want him to be disadvantaged. And so when he comes home today, I will let him know. Whenever I see your pay slip again, I mean, your money, I want to see what is being deducted, because the other day they started doing their health coverage, and, you know, he's paying, I guess it's contributory, and he's paying, I think, $59 every week. And I'm like, what kind of insurance are you paying that is $59 a week?
Because you may find out after a year, he's not even, he don't have any insurance.
Right, because I told him, I said, where's the contract for this insurance? What are the benefits? What are you entitled to under this $59 a week?
Yeah.
And I've told him to go back to the manager or his uncle or whoever's in charge of that area and let them give him something in writing to show, because if anything happens to him, he works at a very hazardous job. And if anything happens, I need to have these documents so that I can know what he's entitled to.
Right. So you should have that, and the employer should have it as a record, because you as the employer are required to keep records. So even if he's not taking a pay slip home, you should have somewhere in your organization where he signs for what he's getting. And you would be able to prove that you paid him this, you take this away, and so forth and so on, because you don't want to be left holding the bag as the employer, and you as the employee want to make sure what is being taken out. You can show proof that has been taken out. Because when you go to national insurance to say, I've been working for these people place for the last 2 years, the people could very well say you never was working here if you've been getting paid in cash and there's no record of your employment.
Okay, I need to enforce that, because like I said, if anything happens to him and he's unable to speak, they could tell me it's not so. You see what I'm saying?
Yeah, so you must have something for your own purposes. Just like you should have a contract of employment, you should have your pay slip as well.
Okay, because I get one every 2 weeks, so that's why I
Right, so you must have that, so you can prove you working here and you actually get paid.
All right, so I will make sure I enforce that when he comes home today.
Certainly.
Thank you.
Yes. then you have a duty to ensure, as far as is reasonably practicable, the health and safety and welfare of your employees, protecting them from risks arising from work under the provisions of the Health and Safety Act. So in addition to that, they must make sure they provide information on training and health, safety, conditions, and standards. So they should tell you more or less, when you come here, not only I have a duty to you, I have a duty to my customers. So when you come here, you must ensure you observe certain protocols. You're not allowed to go in a work area that's hazardous without certain protective equipment on. You should be trained in the area of using the equipment. You should drive, ensure you have a valid driver's license. You should make sure you wear all those things. So you, as the employer, ensure they do what they have to do. So anything that they do outside of what you would have enforced, then it's not only on you. If you get a court case, for example, and your employee was in an accident in your vehicle, you clearly stated there should be no riders. So they were given a ride to somebody. That's against your company policy. The person got in an accident, no one was wearing seat belts. And that's clearly on the dashboard. No riders. Please ensure all equipment is properly functioned before you leave the yard. Ensure you wear your seatbelt, because I'm not responsible for any tickets you get if you are not wearing the seatbelt or observing the road safety laws. You see, usually some companies have on the back, if you see this vehicle being driven recklessly, please call, because they're protecting themselves. So they're showing that they're taking some extra steps to ensure that they're not going to be out there liable for whatever is going on. So they try to help as much as possible. So in that case, the liability will be shared between them and the employee, because notwithstanding the employee is acting outside, they can show that they've taken the necessary steps for the employee to do what they were supposed to be doing. They're making sure that the control and usage, storage, maintenance of dangerous substances, they have control of that. They should ensure everything is in place. They should establish safety committees where it's necessary, and consult with union regarding health and safety standards, information, training, for the employees. So where the employees may complain that, well, this look like mold in the building, the employer should ensure that it's not mold in the building. If they see something is deteriorating, they should take extra steps to make sure that the employees are not affected. They should take reasonable care to ensure that the tools, equipment, system, environment of work used in the business are safe, and that the employees selected to perform the work are competent. So the butcher in the food store should have been trained and should know how to use the equipment. You shouldn't just pick up one of the shelf boys to come and cut meat. Somebody should have been trained to know how to use that equipment, because that's dangerous. They could cut off their fingers, hands, and then you'll be responsible, because now you put them in that situation where they were not properly trained. So they under a duty to provide safety to their employees. They should treat all employees fairly, reasonably, and with respect. And what is fair and reasonable is dependent on the facts of each case. So I should not, if both of us are working in the same position, I shouldn't see that you're favoring one over the other, or you paying somebody a lot more than we are. We start at the same time, we doing the same work. And unless you can show why it is that there's such a disparity in the salaries, or I am being burdened with work while the other person could twiddle their thumbs all day, then it should, you have a duty. I can now, what I'm going to claim. What I'm going to say.
Sorry, in a situation like you said just now, so seniority, that where does that fit in on a job, I should say? Because based on what you said just now, where does that fit in seniority? Is that a part of, would that be something, I guess, synonymous to the organizations, or? Because I don't think that's common.
That's a common law practice. You moving up the ranks, and you're the first in line to get the next post, not the person who's your junior, because you would have worked your way up the line. So you should be the next person in line. So they have senior vice presidents, and then they have vice presidents. They have senior this, and then they have the regular, so that differentiates the post, eh? So it tells that you've been there longer, or you have more experience, or you are high up in the ranks. So seniority has its privileges in the organization, and they should be recognized first, if they are qualified and they've been working at it. So
I think that's the caveat right there. If they're qualified and they have the skill sets, because you could have a junior person who is
that's
brilliant.
Right, Catherine. Yeah. That's it right there. I was trying to get to too.
Right. So now, notwithstanding that, you have a junior person who would have just come in, and I'm a senior person. Now, they have people who just socially promoted just like they do in school.
Mm-hmm.
So it could cause other persons to be disgruntled in the organization. But then you have legitimate persons who are senior and they can do the job. And then you have junior persons who may have been more qualified than the senior person. But the senior person can run circles around the junior person. Notwithstanding that they may promote somebody over me, who I have to now train to do the job that they've promoted them to do. So it could be unfair on either end.
Right. Because especially in HR, Ms. Dorset, you have some persons who have been in HR since they started working, and they've just learned by rote, circumstances. Then you have new and upcoming professionals who have done the training. They have some, they have experience. Let's say they've been in the HR field for a few years. They're not green, but they certainly are much better versed. Persons who take this course, for example, and to say that they can't be promoted because there's a senior person who's just sat in the saddle longer is a detriment to them.
Yes, certainly. So it's dependent upon the facts of every case. Yes.
Yes.
So that's the difference there. Then they have the duty to conduct themselves and his business in a manner that does not destroy or damage the relationship of trust and confidence between him and his employees, or in any way affect the employee's future employment prospects. When you get the book, you'll have this case that's on page 100 to 103 in the labor law book. And it's an interesting read because in this instance, these fellows were working for this Bank of Credit and Commerce, and they went under. And they couldn't get jobs in the field of their choosing because they were associated to have worked in this organization that would have defrauded or done something. So just guilt by association, I don't want nothing to do with you all because everybody in there was crooks. You see? So no, this Credit and Commerce, they used to be through George Street.
Oh, because I know anyone with that Swiss thing that Brown and a lot of people do.
Yes. So sometimes you can't get anywhere with that. Likewise, on point 4, page 104 to 106, you'll find those cases, Wilson and Clyde and General Cleaning Contractors in the book. Duty to indemnify the employees against any claims, debts, or expenses and liabilities reasonably incurred in the course of his employment. So if I incur any debt as a result of me working for you or doing something, I should be able to recover my liability or expense. Duty to provide work where the wages or salaries of the employees are dependent upon the work supplied. So if I'm working on commission, you should provide me with the work that I would get commission from. So you shouldn't hold out or keep all the work for yourself. So if I'm selling jewelry and you're in the shop all day and you grab all the sales and leave me to only get my base pay a week, that's a problem. Yes, you should make sure that I'm gonna have work that will cause me to be compensated as you would have contractually employed me to do. Now, likewise, the employer is not obliged to provide work if he continues to pay the employee the agreed wages. So I, as an employer, if you don't have any work to do, that's nothing to do with me as an employee. You just make sure I have my pay. So if you realize I don't have nothing to do, you know what you can do as an employer. You can lay me off or you can get rid of me because the position is no longer necessary. But as long as I'm there, you have to pay me. Then you have to pay the national insurance contributions, that's important. And then you have to provide maternity leave with pay once in every 3 years. Additionally, where there's a reference required, you can provide the reference, but you can't provide incorrect information, which may damage the employee's prospect. Now, likewise, you can, as the employer, say that you don't provide references because I don't want to be in no mix up with you all, where you say, I say something, but I shouldn't say it, and I get in all kind of mix up. I done rid of you. I don't want to see you no more. I don't provide references. Go ahead. I don't need to hear from you no more. When you leave, go. So you have that choice to put that in there as well, that we don't provide references. When you leave here, we serve a tax. Right. Because it protects you in any event, because they may come back and say you say something with you even don't know it was an issue. Yes? And we'll find that this case, Spring versus Guardian, on page 106 to 112 in the labor law book.
Okay. Question, Ms. Dorset, is there an obligation to at least provide confirmation of employment?
They could confirm that the person has the right to go to national insurance and show they've been working, something they say.
Like when we're doing background checks, you know, an employer may say, you know, I choose not to give a reference, and in our case, we don't give references.
Right, you might just say they work here.
But right, just confirmation.
Right, but of course, you would have had to get that release from the person, yes?
The release from the ex-employee?
Right.
Yeah, well, typically they are the ones requesting it. You know, I need to just prove to this new guy who's trying to hire me that I worked for you for this period of time that says on my resume.
Right. Because then you could be in mix up on both ends, because then the new employer may say you said something and you know that wasn't to be true. You know, this person was a thief and you still send them over to me.
Wow.
And then the employee may say, you called me a thief and I never stole anything. Oh, Lord. So you just stay out of that free and tell them, have a nice life.
That's tough.
Okay, duties of an employee to an employer. Who can help us with that one?
Continue if you want to.
Thank you.
Okay. Duties of an employee to an employer. The duties of an employee to an employer under the terms of the contract of employment and or under common law and statute are as follows. 1. Duty to provide the employer with honest and faithful service. In the contract of employment, there are often provisions which address the employee's duties to maintain confidentiality regarding the employer's business and proprietary information, not compete with employer's business upon leaving its employment, not to make use of his trade secrets, and not to solicit his clients' customers. Wallace, Bogan and Company versus Cove and Oz. HIVAC Limited versus Park Royal Scientific Instruments Limited. Alperton Rubber Company versus Manning. Stevenson, Jordan and Harrison Limited versus McDonald's and Evans. Worthington Pumping Engine Company versus Moore, British Siphon versus Homewood, British Reinforced Concrete Engineering Company versus Lind.
Okay, we'll find Wallace on page 114 to 116. I mean 113 to 114, and HIVAC on 114 to 116 in the labor law book.
Okay. 2, duty not to make any secret profit from his employment. If he does so, the employee has a duty to account to his employer for the profit made. The employee has an ancillary duty not to accept bribes, unauthorized gifts and commissions, or any reward or benefit which may ICE Company versus Ansel. 3, duty all property entrusted to his care, supervision, and attention, and for any and all property received from a third party for, on behalf, and on account of his employer. Superlux versus Playsted. 4, duty to perform his work competently. Lister versus Romford Ice and Cold Storage Company Limited. In the absence of clear whistleblowing legislation and where there is no whistleblowing policy within the employer's organization, the employee has no legal obligation to disclose his or his employee's misconduct, although he is under a general duty of fidelity to his employer. 5, duty to obey all reasonable and lawful orders and demands by his employer. 6, duty to use all reasonable skill and care in work he is engaged or contractually obliged to do under the express or implied terms and conditions of the contract of employment. Example, this does not apply to any work extraneous to or outside the scope of his employment. 7, duty not to damage, deface, or misuse his employer's property or co-worker's property. 8, duty not to do any act which may cause injury to his co-workers. 9, duty not to do any act which may cause financial loss or damage to his employer. 10, duty to act with fidelity towards his employer and his employer's business.
Okay, so the duties of an employee to an employer. So you see what the first thing is, honest and faithful service.
Amen.
You know, that's a big deal over here and anywhere, I guess you could say. So, you know, they're supposed to ensure to keep matters private that are within the organization. And they should not compete with the employer's business upon leaving, and not to make his trade secrets known to anyone else, or not solicit his customers or clients. So the employee is supposed to do this. This is something that's a duty you owe to your employer. You should not make a secret profit from your employment. That includes bribes. You make a secret profit.
That's considered tips too?
Yeah, that's bribes.
and paying you to push my thing through faster? That's
yes, yes. You are accountable to your employer for these things. So unauthorized gifts and commissions or any reward or benefit which may compromise you in the discharge of your duties, you're not to do that.
What if it comes after my duties would have been performed? And I guess my customer or my client was pleased. That's still an issue?
So that's an incentive. That seemed like you got an incentive to do that. You knew that incentive was coming thereafter.
Okay.
Duty to account for all property entrusted to your care, supervision, and attention, and all property received from a third party on behalf of the employer. So you're responsible for that. You have to account for it. You are to perform your work competently. In the absence of whistleblowing, there's no whistleblowing policy within the employer's organization. They have no obligation to disclose his or her employer's misconduct, although he's under a general duty of fidelity to his employer. So, you know, we have where you have to report certain things on the compulsion of certain acts, and for you not to be imprisoned as well with your employer if you know they're doing something untoward. So you are protected by those laws. But other than that, you don't go disclosing these people's business out there just because you could talk. And then you should be able to perform your work competently. You shouldn't come on the interview, say you could do certain things and no, you can't do it, and you messing up the place. Duty to obey all reasonable and lawful orders and demands by the employer. So what is reasonable is, again, based on the surrounding circumstances. But I shouldn't have, if I tell you something, you telling me you're not gonna do it. What that's grounds for?
Dismissal.
Dismissal.
So that's summary dismissal. Yeah.
It's subordination.
Right. Duty to use all reasonable skill and care in the work you're engaged to do, contract, and you're contractually obliged to do. So this is not work outside of your employment, the scope of your employment, but within the scope of your employment. Now, sometimes you may go above and beyond. That's outside the scope of your employment. That's, you're not obliged to do that. So you're doing it of your own volition. Duty not to damage, deface, or misuse the employer's property or co-worker's property. So you shouldn't, you have a duty to be what? Would we start off with? This comes under, yeah, honest and faithful. You have a duty not to act in any way which may cause injury to your co-worker. You have a duty not to act which may cause financial loss or damage to your employer. So you could be trading and you're supposed to put in a trade and you're busy talking and the time passing, the client lose all their shirt and all. Because you've not done that, you have a duty not to do that, and they could come after you, eh? They're gonna fire you first of all.
Yeah.
But they may say this damage may be beyond them because you were not acting what?
Responsibly.
And you were not competent in your duties.
Honestly, and
you have a duty to act with fidelity towards the employer and the employer's business. So you should be honest and faithful. You shouldn't be dishonest, and you should do what you're supposed to be doing and not other things, not making secret profits, not doing all these things. Do your work and be truthful in your employment with your employer. Okay, rights of the employee.
I have a question, Ms. Dorsett.
Go ahead.
With item 1, is there a time limit regarding the period when an employee leaves where they cannot compete with their employer's clients or persons who were clients at the time of their employment? Is there an end date for that?
I don't know that there's an end date, but I may say you would have gained this in the course of your employment, and I may have had you sign a contract, because then I would want you to ensure that you sign that up, eh?
Right, because we talked about this in earlier, and right. if you're in your skill set is something that you can market yourself individually. Let's say you're an electrician, I think was the example we used. Right. When you leave your employer who is in the business of providing electrical services for clients, is there a period of time where you cannot approach their clients or customers, not solicit them? Is that forever?
Well, I mean, you shouldn't solicit their customers based on the fact that you know they were customers of your old workplace. So now if they've now severed relationship, that's a difference. But let them not sever relationship because you provided them to say, if you leave them, I can give you a better price.
That's what you're saying is illegal. If you solicit them and say, come with me, I could do this.
Yeah, so the only reason you know them is because you were working in that place.
The context of your employment, okay.
Right. So within the scope of your employment, you're soliciting the clients. And then you may have had trade secrets. So basically any place that have trade secrets, they would surely have you sign some confidentiality agreement that even when you leave, you cannot use what you would have found out in there outside. Because likewise, when you leave any place like a bank, you can't go out talking about their clients based on the fact that you knew them because you were working in that bank. You're still obliged by that confidentiality agreement.
Okay. Thank you.
Okay, rights of the employee. Who's going to help us with that one?
I can read that.
Thank you.
Rights of the employee. There are certain rights that are enshrined in common law and statute that the employer must recognize, protect, and ensure in relation to employees under a contract of employment. Many of these rights will be explained in more detail in later modules, but the general rights of employees are listed as follows. 1. Right to be treated fairly and equitably, including the right to be paid the requisite minimum wage and for hours, holidays, and overtime work. 2. Right not to be discriminated based upon race, color, sex, religion, sexual orientation, disability, and/or trade union participation or membership. 3. Right to an itemized payment statement slip. 4. Right to be informed of grievance and disciplinary procedures, especially information on the grounds for dismissal. 5. Right to information on health and safety requirements. 6. Right to time off for public duties, example, jury duty. However, the employer is not obliged to pay for absences. 7. Right to time off with pay for trade union duties if a union official. 8. Right to be remunerated for a certain number of days for absence from work due to medical reasons, subject to terms and conditions of employment. 9. Right to maternity leave and/or paternity leave time off benefits. 10. Right to have the required national insurance contributions paid by the employer. The developments in employment legislation has demonstrated an increasing awareness and need to protect certain rights of the employee and ensure that those rights are properly recognized through written terms and conditions, workplace policies and procedures, and best practices. Bahamian legislation still has some ways to go to keep pace with the legislative developments in the UK, example, Employment Rights Act 1996. Significant gains in the recognition of employee rights against issues such as sexual harassment, gender and sexual orientation discrimination, disability discrimination, HIV/AIDS discrimination, discrimination based on trade union activism, and other inequalities have developed over the past 2 decades, both in the United Kingdom and the United States, as new social and economic realities become workplace norms.
Okay, so we have the rights of the employee, and they're enshrined, some of them are enshrined in common law and statute that the employer must recognize, protect, and ensure in relation to the employees under the contract of employment. So they must be treated fairly and equitably. So that's including the right to be paid the minimum wage, holidays, and overtime hours. Work they should be paid for. They should not be discriminated against because of their race, color, sex, religion, or sexual orientation, disability, or trade union participation or membership. They have a right to an itemized pay statement or slip. They should be informed of grievance and disciplinary policies and procedures, especially grounds of information on grounds for dismissal. So you should provide them with, if they have a grievance, what they can do. If there's disciplinary process or procedures, you should advise them and inform them. They have a right to information on health and safety requirements, right to time off for public duties, right to time off with pay for trade union duties. If you're a union official, they should be remunerated for certain days off for absence from work due to medical reasons. Of course, it's subject to terms and conditions of the employment. They have right to maternity leave and or paternity leave time off benefits, and they have the right to have the required national insurance contributions paid by the employer. What is the required national contributions by the employer? What is their percentage to pay?
5.9.
Yes, 5.9%. So we have laws that are developing, but we have some ways to go in the Bahamas, to keep pace with the legislative developments in the UK, in particular, the Employment Rights Act. Of course, we have some protections and recognition of employees' rights, in particular where it comes to discrimination on trade union activities, on HIV, AIDS, and inequalities in general. But we have developed a bit, but it's not where it should be as yet, because of course we still get trampled on as workers. Yes?
Ms. Dawson. In the news, I think Wednesday, they spoke of a security guard who died at one of the schools.
Right.
He was on duty by himself. And we've learned in terms of the rights of an employee and all of that. Do you think his family would have any recourse?
Now, it's according to what was the surrounding circumstances, eh? What he died as a result of?
I think it was natural causes, but I think the argument could be that because he was there by himself.
Yeah, because he might have been able to get help if something was wrong.
If somebody else was there.
Yeah. Right, but so what I'm saying is, what if it's natural causes is not as a result of the job, eh?
No, but if
the job may not have required to have 2 security guards. You need to sit one place, or if he had help, but likewise he could have been home and someone might not have been, he may have been alone at home.
So you're saying basically outside of his contract that he would have signed and the family has no recourse?
Not unless it's something job related that he died as a result of his job.
Okay,
but if he died within the course of his employment, they can just get the benefit what they're supposed to get, and that's it.
Okay, all right.
Okay, Tasha,
I have a quick question. Item 1, the right to be paid fairly and equitably. Can payment be something other than cash? Can it be, say, for example, traded days, say for a holiday, at the same rate as if you were being paid? So you work a holiday, you get 2 days off.
Right, so your payment is based on your benefits. So you may be getting $20, whilst I may be getting $40. But I'm getting $40. I don't have 2 days off every week. I am not able to come in at 1 o'clock on Wednesday.
I was referring to like a public holiday. Does the employer have the right to say, I need you to work on this holiday, and instead of giving you double pay for it, I will give you 2 days off instead?
Well, that's if you agree to take it like that, because you may say, no, I rather get paid. I may need that money more than I need the 2 days off.
The 2 days off.
Right.
So it must be an agreed.
Right. It has to be agreed. Right. Because what we say, when you vary my terms, certain times you can't. Right. You can't vary it unilaterally. Right. It has to be agreed.
But a number of businesses are doing that, because my nieces used to work at a business where they made the decision not to pay, but give them the days back. And it's like, I don't care if you have an issue with it. And eventually her, along with a number of other employees, were fired.
So did they dispute it?
I
remember what we say they have to do. They make their dispute known in writing.
These Christian people, they don't do these things, but they was eventually paid. She was eventually paid. She was compensated for her years there, but I'm saying when we started early, I said a number of labor laws are being broken left, right, and center in this country.
Right. And but that's because people don't know, right? Because
it's not. No, but remember now, Ms. Dawson, not everybody don't know their rights, but you just, like you said, the red tape, the task,
what it takes to go through. How can
the pushback.
Right, but you see, that's the disadvantage that the Bahamian society faces, because we worry about the time frame or the difficulty. We just want things to happen too quickly. But if you want things to happen, you really have to follow through, especially in this system that lies on everything. But if they have an idea that there's going to be some recourse, that you really going to follow through or pursue something, they would think twice. But because they know that Bahamians, they don't want to be, I'm not going to court, I'm going to be waiting on this judge all day, this and the next thing. It eventually becomes common practice that it's not going to happen. So when you go to court, they'll turn you around a million times because they know only you one coming. Ain't nobody else coming.
Now for me, now this is just my opinion. You find that a lot of times these type of situations happen, especially in the hotel industry.
Right.
And to me, and like I said, this is just my opinion, but I feel like a lot of times when we do business here in the Bahamas, that so many things happen during contract signing, the pay under the table and all of that, that the employee is at a disadvantage from the beginning. Because if my employer does something, the ever and get there under the table. And so that's not going. There's no one really to stand up and say, look here, this hotel has been at a disadvantage, because I think there was another entity that left here and took all the person's monies and everything, and nothing came out of it.
Right. So what I'm saying to you is, until we change how we process and how we act and behave towards things, it's going to continue to happen, because our position is you really ain't gonna get no results. So what's the point? So because everyone is aware that that's our attitude, they take advantage of that. So a lot of times people really have legitimate legal concerns, and they really can pursue it and get results. But these people base it on the fact that they're not going to pursue that, or I'll make it so difficult that they're not going to want to do anything further with this, or I'll pay 2 more employees something extra so they don't even speak up on your behalf. So that's our society. That's how we handle things, and that's why we're treated the way we are, because we're not together. That's the first thing, and we don't follow through. It's too difficult. We're not doing all of that.
But it seems like with my organization, we had an incident where we had an employee that was dismissed, and he said that he was going to fight it. And you know what they said? Well, if you want to wake up the sleeping giant, that's what most organizations refer to themselves.
Yeah. So is that something for me to be intimidated by?
Right. So, but he fought it, and his judgment didn't come until 8 years later.
But see, that's because what I'm saying to you is that's because of society as a whole. If you had sufficient people who are going to come to the courthouse, the court will not be minded to wait 8 years to get to a judgment, because there's so many people who lining up that they know they have to deal with these things more expeditiously. So if is only 1 in 10 people going to come to the courthouse, well, when they reach, we'll just drag this out. But if you know you have cases line up every minute, you do something wrong. Because if you go to the United States, you know that's a litigious society, eh?
Yeah, Jesus.
And you know if you walk into this one, you getting sued.
Right.
You know, if you slide down in Walmart, you getting sued. So they take so much care, because these people have them on the edge of their seat. They're going to enforce their rights, but Bahamians are not going to do that. So I don't have to worry. I as an employer could take advantage of you all day. By the time it's the labor board call you twice, you say, man, I ain't going there today. I ain't putting on no clothes. I ain't wasting no time with them. You think the employer won't send their attorneys or whoever still? They know you're not coming.
The other employees might be afraid to stand with that person too.
Because but what you have to lose?
Your job.
And your job.
No, what I'm saying to you is, if it happened to me, it's soon enough will happen to you.
Yeah.
And if it happening to me, you already experiencing those same things that happened to me, and you have to do so much just to stay. You have to stay silent and suffer when you can actually stand up to see what I'm saying is, until we stand up, our rights are not going to be recognized. And so if it happening, you know, they've been talking about that, the thing where they say it ain't happening to me now. You know that,
Me too.
You know that the one where
the Me Too movement?
No, the one where the poem they were talking about so much.
Okay. Don't know
that I will tell you, I'll send it to you so you'll get it. So when it break down to this, I saw this one, it happened to this one, but I was in the war, so it happened to this one. That don't affect me, so I say nothing. And then when I found out there was only me one left, because I allowed, so I had 5 people working with me. That happened to Jane, but Jane was the problem. It happened to John. John was the, that ain't me, I ain't getting in that. So that's Bahamians on the whole.
I was just gonna say, Ms. Dorset, I think that's a Bahamian thing for real.
Yeah, what I'm saying is, you know, everybody has a voice outside of the employer. Yeah, no man, she too disgusting. She doing this, she doing that. When you reach a meeting, the very one who say, well, don't, I could tell her. Everybody say, yeah, you tell her with you. When she reached there, they tell her you leave. And the rest of them out stiff. You don't even know they were in the meeting before. So you're in shock, but you're the only one going out the door. And so they're gonna continue to experience those injustices because they don't stand up for themselves.
And another thing too, I think to the common Bahamian employee, it's really a matter of financial disability, because a lot of people, when they really think about these kind of things, they usually associate it with money and having to get a lawyer. And when you hear an employer say, we want to make a sleeping giant, that's basically a play on the mental, but a play on the mental toward their financial situation, because now they're already removing you from their job, and basically they would take, they already have a profile and you saying that, okay, you probably wouldn't have this amount of money. So if the longest you might try to draw this, so you ain't have the money to sustain this. So
right.
That's the biggest thing.
You see some people start, they don't, you see what some people do is, just take for instance, that fellow with the football. He didn't start an action on his own. He started a class action suit. So what he's done is he's invited others to join him who've experienced that. And so you would find, you're going to soon see a lot of people joining with him against the NFL for inequalities and things that have happened. Now, you know, he's been in there for some time and he's had his mouth closed. All these things that were happening. Remember that fella Colin Kaepernick? They were
yeah.
He was right there all the while, and he wasn't saying nothing. Now all of a sudden, it happened to him, and now he wanted the world to help him out. But that's how it is. You'll soon find yourself alone. So this is the quotation is from this fellow Martin Niemöller, and he said, this is the quote that they come from. First, they came for the socialists, and I did not speak out because I was not a socialist. Then they came for the trade unionists, and I did not speak out because I was not a trade unionist. Then they came for the Jews, and I did not speak out because I was not a Jew. Then they came for me, and there was no one left to speak for me.
Everyone was gone.
That's right. So that's what is the Bahamian society as a whole. That ain't my business.
Ms. Dorset, but class action suits give results, but do we have them here in the Bahamas?
Well, you have to have a class to act first. You see, we can have that, but we don't have nobody to join in.
Understood.
Yeah, so that's the disadvantage there. All right, so let's go on to Tasha's relationship. So I'll be finished by 11:45 today. I have one little engagement. I apologize. Who can help us with Tasha's relationship?
Read. I'll take it, Ms. Dorset.
Thank you.
Tasha's relationship between employer and employee. In the law of tort, vicarious liability is the legal concept where one person is responsible to another person, often a third party, for the act or the acts of someone under his employment, care, power, or control. For example, under the law of agency, a principal is liable for the acts of his agent, whether the authority given to that agent is actual or apparent authority to perform or undertake some act on behalf of the principal. With regard to the employer-employee relationship, the ancillary doctrine of respondent superior, meaning let the person higher up answer, makes the employer vicariously liable for the acts of his employee performed during the course of his employment. It should also be noted that an employer may also be vicariously liable for the acts of his independent contractors in certain circumstances and subject to the terms and conditions of the independent contractor's engagement or employment. The employee must be acting within the scope of his employment for the employer to the vicariously liable to a third party for the employee's action. Any act done outside the scope of his employment will make the employee directly liable to the third party who may have suffered some loss, damage, or injury due to such an act. Example, traveling to and from work is generally not considered within the scope of an employee's work, nor is picking up an unauthorized passenger while on company time and business. If the employee's act is not entirely within the scope of his employment, but is connected to it or is reasonably foreseeable based upon the nature of his work, the employer will be held liable to the injured or aggrieved third party. Similarly, if the employee commits an expressly forbidden act within the scope of his work, or the employee negligently delegates his or her rights and authority to another person without the employer's permission, the employer will be held liable for vicarious liability. Some examples where an employer may be liable to a third party under the concept of vicarious liability. 1, an overzealous security guard falsely imprisons a customer whom he suspects of shoplifting in the company office or injures them due to excessive force or action. 2, an employee driver accidentally knocks down a pedestrian while en route to delivering a pizza to a customer without any evidence of speeding, etc. 3, a negligent employee fails to place signage of wet floor after mopping the premises and causes a shopper to slip and break her leg. 4, a bank employee fails to place the out of order sign on a malfunctioning ATM and it dispenses less than the authorized amount to a customer, but his account is debited from the amount requested. If found vicariously liable, an employer may be required to pay damages, costs, and/or expenses to the aggrieved party for the negligence, loss, damage, or injury caused by the employee who commits an act or can be proven to have committed the act or the acts during the course of his employment.
Okay, so we have the tortious relationship. And so the vicarious liability concept is where this comes in. And so now this is where the employer is responsible for the action of their employee, or in the instance of a regular person, it's a person responsible for the action of a third party under their employment care and control. So under the law of emergency, the principal is liable for the acts of his agent where the authority given to the agent is actual or apparent. So if I walk into the bank, like I said, and you have on the bank's uniform, I must assume that you have the authority. It's apparent to me that you must have authority to speak on behalf of the bank as the customer service agent. So what I take from you is basically that you are the bank at that moment, and what you tell me is true, and I can act on it. So you have apparent authority to act. Actual means that you sign in something. I have a document to show that you are the person authorized to sign on behalf of the company, and so I can act on your actual authority as well. You can perform or undertake some act on behalf of the principal. Respondent superior, what this means is the vicarious liability comes under that doctrine. Let the person higher up answer. So when I come to you as an employee where you would have gotten in an accident with me, I'm not holding you responsible. I'm holding the person higher up. That means I'm holding your employer who have you in the scope of his employment to be in an accident with me in his vehicle. I'm holding them responsible for your actions. So they're vicariously liable for what you would have done here today with me. So the employer may be liable for the acts of independent contractors as well in certain circumstances and subject to the terms and conditions of their engagement or employment. So where the independent contractor may be doing work on the building of the employer, and someone may have been injured passing the building because the independent contractor had not taken the necessary care to stabilize the platform or to ensure that bricks weren't falling from the roof when they were working. The employer may be responsible because that's their place of business, eh? So just say, for instance, a bank may hire a cleaning company to come and mop the floor. They're only independent contractors, notwithstanding they put up wet signs, but the floor is so where they should have only mopped a certain area and allowed customers to walk on a dry area and then move when that area is dry, move over to the other side. No, they just slop up the floor, put the wet signs, and the customer may come in. They come in and they fall down and hurt themselves. So now, while the employer, the independent contractor is working for the employer, the client is not going to come to the independent contractor. They're going to go to the bank itself. Now, they could say you're contributory, it's contributory negligence because we had to sign up. You should take necessary care of. You knew you couldn't navigate the floor. You should have waited until the floor was dry. It doesn't matter. The liability is there. So whether I'm found it's contributory negligence where we share the liability, or it's fully, we find that it was just really negligent how they operated, how they have the floor wet, because I still should have been able to navigate over the floor. I had on rubber shoes, so I thought I was safe. You still may be responsible for the actions of the independent contractor in that instance. In order for the employer to be responsible for the actions of his employees, the employee would be say must be acting within the scope of his employment. Anything outside, the employee is directly liable to the third party. It won't be the employer's fault. It must have been connected with or reasonably foreseeable based on the nature of the work of the employee that it could have happened. So now the employer will be responsible for whatever happens.
So I have a question right there.
Okay, go ahead.
You have sometimes a lot of people, the boss or managers, they like to call them, like to send people to like pick up their kids from school.
Mm-hmm.
And in the event something happens and like that. And
so now that's the manager acting with his authority as the an employee as well. That's outside of the scope of the employment of the employee. Because listen what the insurance could tell you. You mash up the car, where he was going. Because the minute he said he was going to pick up the manager, son or daughter, you know the insurance out of that.
Mm-hmm.
So that's the first thing. So if the insurance could get out of it, what you think about the employer?
The employer that's what I'm saying. Because now
yeah, because he still was driving the company car. He was within the hours of employment, and notwithstanding, you were responsible to ensure that your manager know under no circumstances this company vehicle is to be used for anything other than working here. So now the employee was acting on the instructions of his manager, and so the employer will still be liable.
Okay.
Okay. Because what we say, if the employee commits an expressly forbidden act within the scope of his work, or the employee negligently delegates his or her rights and authority to another person without the employee's permission, the employee will be held liable for vicarious liability. Yes?
Yeah.
Mm-hmm. So we have an overzealous security guard. You know, we have them a lot.
Mm-hmm.
We have an employee who accidentally knocks down a pedestrian. We have a negligent employee who fails to place signage of wet floor. And we have a bank employee who fails to place the out of order sign on the ATM. So in all those instances, the employer will be required to pay where he's found liable, damages, costs, and or expenses to the aggrieved party for negligent loss, damage, or injury caused by the employee who commits the act or can be proven to have committed the act during the course of his employment. So we must make sure that's the key component during the course of his employment. Okay, let's answer our questions. Number one, nature of the employer-employee relationship. Where we'll find that answer.
Page 58.
58, and what is that?
An agreement between the parties as it relates to pay, benefits, working conditions, etc.
Okay, we're looking at page 58, number one. What is the nature?
Maybe oral, written.
Contractual.
It's contractual in nature.
Mm-hmm.
Yeah, so it's the nature of the relationship is a contractual one.
Yes.
Number two, define the different types of employees. Where we'll find that answer.
59.
On page 59.
And what are they?
Employee, agency worker, or self-employed.
Okay. Number three, define an employer. Where we'll find an employer.
Page 60.
Page 60.
And what is that?
An individual, business, or legal entity that hires another individual or individuals to work under contract
of employment. Number four, what are the duties of an employer? We will find that answer.
Page 60,
61.
61.
62.
Okay, so we have 60 to 62. We'll find the duties. Give me two duties, please.
Provide an employee with an itemized pay slip.
Treat all employees
provide
fairly.
Maternity leave.
Okay, and treat all employees fairly.
Yes.
Duties of an employee to an employer, we will find that answer.
Page 62.
62 to 64.
62 to 64.
Yes.
Give me two duties of an employee.
Not to damage, deface, or misuse the employee's property.
To
obey all reasonable and lawful orders.
Okay.
And demands by the employer.
Okay. What are the rights of an employee? Where we'll find that answer.
64.
64?
Yeah.
Give me two rights, please.
Right to be treated respectfully, and the right to be discriminated.
Okay. Explain vicarious liability. Where we'll find that answer.
Page 65.
Page 65.
And it is the legal concept where one person is reasonable for another person of someone under his employment, care, power, or control.
Okay, responsible for another. When is an employer vicariously liable for the actions of his employee? Where we'll find that answer.
Okay, 65.
Okay, when is he liable?
When they're performing in the scope of their duties.
Excellent.
Under the employment.
Okay, when is an employer not vicariously liable for the actions of his employee?
He's acting on his own.
And what is that?
The Employees Act is not entirely within the scope of his employment.
Right, so that's on page 65 in the same paragraph, right?
Yes.
Give some of your own examples of your answers to question 8 and 9. Give me an example of where an employer is vicariously liable for the actions of his employee.
Employer is liable.
When he go to pick up the children from school.
Okay.
And he gets an accident.
Yes. When he goes to pick up which children?
The employer. Just children.
During his what?
Employment.
During his lunch hours?
No. Yes, during his work.
During his work hours.
He's picking up the children, and who's not responsible?
The employer is not.
He's picking up the children during his work hours.
During his work hours.
But without the
employer would be responsible.
Yes. So we say
because he was acting under advice, under direction from his manager.
Right.
Okay. He's picking up his own children.
Your boss come in and tell you, go pick up my boy from school. So I going to pick up my boss son.
Yes. Okay. Yes, boss is responsible.
What if he was picking up his own children?
If he's picking up his own children on his lunch break, then no.
The employer is not.
Right. Okay, what if he was dropping his children off when he was supposed to be dropping something else off?
The employer is not.
The employee is responsible.
And you don't write that story like that.
But he was dropping his children off to school 10 o'clock in the morning, and he was supposed to be by the airport. Who's responsible?
The employee.
No, he's within the scope of his employment hours.
Yeah, but he's not doing the employer's work.
He's not doing the employment act.
Yeah, but what we say about that?
They share the responsibility.
If an employee commits an expressly forbidden act within the scope of his work, or the employee negligently delegates his or her authority to another person without the employer's permission, who would be held vicariously liable?
The employee.
The employer. Look on page 65. Remember, I just showed you all that? That's under on the third paragraph.
If you do something that you were not authorized to do or directed to do, how am I as the employer responsible for your actions that you had no approval to do?
So because it's reasonably foreseeable? His actions are reasonably foreseeable?
You give him a whole truck and car and you're keeping the grass ahead.
So it's reasonably foreseeable that he's going to do some personal errands.
Yeah,
but I didn't authorize him to do that.
Listen, expressly forbidden. You mash up a whole person. You write off their truck. You in the big van would say ABC Company Limited. And what you doing in the van? You had a permission to use the van.
Yeah. To go do my business,
not to do your own business.
Exactly. That ain't nothing to do with me as the third party.
Like I guess the big difference is
we could argue that
you're in the company's vehicle. I was thinking in terms of I was in my personal vehicle.
Right. Now, see, you as the employer may have some recourse against the employee directly, but me as the third party, I don't care how y'all work that out. Just fix my car.
Okay.
You see, that's what I'm saying. You vicariously liable.
Yeah.
Because your car on the road and someone driving it, you must be know what they was doing. That ain't nothing to do with it.
So if you had a case where the employee at 10 o'clock is dropping his kids on.
You went out.
Catherine, you're offline.
Okay, give me an example of where the employer may not be vicariously liable. What would we say?
The employer may not.
I have a possible scenario where an employee was on their break and they were making some tea and got scalded by the tea that they were making and wanted to claim industrial.
So that's health and safety at work.
Yeah.
Yeah. So we could be claiming it.
Well, National Insurance didn't seem to agree.
Well, whose teapot was it?
Now, listen now, industrial means you have to be recognized by National Insurance as industrial. Remember that. Your work has to be categorized as industrial. You can't call getting called with tea industrial.
What?
Yeah, this is not industrial.
Yeah, no, but I mean, what if I'm a waitress? I mean, that's different. That's a part of my.
I guess it's based within the scope.
If I'm an accountant,
it has to fall within the national insurance category of industrial.
Which is
so they're not going to pay you if you just come, and that's not a category they determine as industrial, because I think you even pay a difference.
If you slip and fall, that is, right?
If you slip and fall, is that industrial unless you're working in that category? Because that's something that's foreseeable that's gonna happen in that area.
What do you?
So if a janitress,
I have people slipping and falling every day, and they're out on industrial leave for years.
Yeah, but what is industrial?
They work in the office
while they to work.
Yeah, but what is industrial? Like what is that category?
That person probably knows someone on the job.
National insurance, well, what we find is once it happens on duty,
the job, yes,
directly related to your work. And case in point, if I'm in the office and I slip on the floor, once I did not cause the accident, or I was, case in point, like I have a staff member who fell out of a chair, but the chair was not on its four legs. So we have an eyewitness that they were leaning the chair back.
So
that was what they reported. So national insurance did not cover that as an industrial.
That's not industrial. I wouldn't consider that industrial either.
Yeah, they were doing foolishness in the chair.
Right. I wouldn't consider that industrial.
Right. So let's look. That's your homework then. Let's see what is covered under industrial for next week.
Okay.
Because the national insurance like to deny your claim in that area in particular. So look at that and let me know what are the industrial, when can we claim under industrial benefit with national insurance? Okay.
All right.
Okay.
Okay, so I will we have our last class next week. So we should be sufficiently covered and know modules 1 to 4 very well, and only 5 we have to review it.
Yes.
Y'all feel comfortable enough that y'all know module 1 to 4?
A bit of minor recap, possibly.
We need to go.
A brief recap.
Yes.
That is a lot of important and technical information. So yes, we need a recap.
Okay, certainly.
And Ms. Dawson, I may have missed it. The midterm, what type of midterm are we looking at? Essay questions,
now,
short answers.
Usually, Miss Archer, who y'all have next? Miss Archer?
Yes.
Yes.
Okay, she will do the exam. So that's the perfect person for you to ask.
For the midterm?
Yes.
Okay.
We won't meet.
We won't meet her until after the
midterm.
On the schedule. Based on the
schedule. Okay. But I'll let you know next week. We'll be looking at.
Okay.
Okay.
And what about the case study? When are we gonna get that? I guess because we need to start.
I saw something come through the email.
I saw Ms. Dean just sent it.
Okay. So you have it?
She just sent it a little while ago, as well as the note to say to collect the book from school.
Excellent, good stuff.
Is the school office open today or Monday?
Yeah, it's open, I think, till about 2 o'clock, I think. You could call.
Where exactly, Ms. Dawson?
It's right on the corner. It's right on the corner of Shirley Street and Elizabeth Avenue, the pink building right on the corner where the red light is.
Directly opposite the new portion of the hospital.
Is that where social services is?
Right around the corner. They share one building, but you just go around onto Elizabeth Avenue side to enter the door.
The spot would be the parking lot by Jeffrey Jones. If you park in that lot under the tree and then you walk under the building awning, there's an opening in the building.
Right. Or you can be lawless and park on the sidewalk and run upstairs.
Yeah, right.
Yeah, which is what
I would suggest against that.
Of course.
Or park in Graham Thompson's parking lot.
Yeah. If the fella allows you, well, the fella will allow you, and once you say
once you tell him you're going to Biffest,
the best he'll let you park.
Right.
Okay.
All right. Y'all take care. Enjoy your week, and don't forget looking at industrial benefits.
Yeah.
Be safe, all. Thank you.
Okay. Thank you.
Thank you.
Bye.